want to ask you this, that does India need a better securities regulation framework against misleading reports that could lead to loss of thousands of crores? Also, lead to erosions of savings of so many people who invest in the securities market. Your opinion and analysis on this very crucial issue.
Yeah, thank you, Tarun. Obviously, this comes up in the context of the recent Hindenburg report and, what it has done to the Indian equity markets, particularly stocks of some selected companies. Now, to my mind, the issue, of course, is larger in as much as any time there is a dissemination of misleading or inaccurate information, its impact could be felt by an individual who may suffer a loss of reputation and go right up to destabilizing the economy of a nation. And therefore, the width and impact of this could be absolutely immense. And I think what we've seen in this instance is that, billions of dollars of market capitalization has been wiped out, which really means that lakhs of shareholders have suffered a huge erosion in the context of their investments, their savings. The citizens impacted would run, I would think, into the millions. And the issue, therefore, is the moment this sort of information gets out, its impact is in a matter of minutes. Your ability to undo this in the matter of issuing a clarification or in the manner of, getting an entire mechanism working to take some corrective action in terms of this could take hours, could take days. But in the meantime, the damage has been suffered. Now, the way I see it is a lot of the international law really is around this concept of abusive short selling, which means that somebody for a personal gain, where they have a position in a particular share, spreads misinformation and then seeks to benefit from that misinformation. And I think if we look at the US securities laws, there are specific provisions, section 9, 10, 17A, which sort of deal with this issue. And the consequences typically have been threefold. So one is retributive, that, you disgorge whatever is your gain, you are delicensed, and then in certain instances, there is a quite heavy penalty over and above. There have also been cases where they've seen this as criminal fraud in the US. And in the El Gindi case, there was a criminal prosecution which resulted in 11 years of imprisonment. So I think that's sort of probably the leading global law on that. Domestically, of course, qua misinformation, SEBI has a right under section 12A. We have the regulations to prevent fraudulent and unfair practices in the market. The question is, are these enough in the context of the challenge of news and information going viral and the impact of that being felt literally in a matter of a few hours or a few days? And I think today, the global law seems to be a step short for two reasons. One, the ability of the law to act at speed is limited. And, depending upon the action you see, suppose somebody said, well, defamation is an action. But we know that, in our jurisdiction, defamation could sort of effectively take years and years and years. And that's not therefore adequate recourse. So I think the first challenge is to have a set of laws where the timeliness of the action is almost instantaneous. Whether, this gets injuncted, whether it gets expunged from the media, whether you have a situation where the regulator says that, look, this is information, but it is not verified information. But something which goes out there and there is a corrective action very quickly. The second is, I think you have jurisdictional challenges. Today, how does, the Indian regulator bring Hindenburg to book? So from that particular perspective, I think like we have in terms of economic offenses, taxation, you need a structure and a framework where different nations are able to participate to take corrective action. And jurisdiction sort of does not effectively become a challenge. And therefore, I think these jurisdictional lines have to be blurred to ensure very expeditious cooperation between different nations to effectively address this sort of thing. The third situation, of course, I think, which needs to be looked at is that while freedom of expression and the writing of reports, we can't prejudge that as always being wrong. And people will say that if the report is accurate, then obviously it needs to be shared and it needs to be known. But given the dangers of a inaccurate report creating chaos in the market, should there be some level of pre-censorship of such reports? Now, you're talking of listed companies, it's a finite pool. Should there be a situation that SEBI does not act post-event, but that there is a situation where such reports are shared with SEBI, and you then have a ombudsman type situation where these then are in a matter of 48 or 72 hours, SEBI comes back to say can publish, cannot publish. And therefore, if we are, bringing something in relation to report or financial reportage of Indian companies, do we have some sort of pre-vetting process? It leaves the question, what happens to foreign participants? But I think any foreign participant commenting on Indian market should also then have to obtain some sort of license and effectively be subject to a pre-scrutiny. This is not to create a muzzle, but this is to create at least some sort of filter that what gets into the market is quite credible. So I think what you need is something which is moves very quickly, moves on international cooperation, and effectively you need not only corrective action, but you also probably need, some sort of pre-censorship or at least pre-vetting in relation to this. And I think, in the larger context and the today context, one of the things which intrigues me is, could the Indian shareholders who've suffered this loss file a class action against the reporting agency? So from this perspective, if let's say a few $1 billion of value has been eroded, if there was possible a class action in US against the agency which issues the report, then I think, agencies will also become a little more responsible, because they then understand that the consequence of something like this could actually be immense in terms of reputation to their own credibility and what they may have to pay up in terms of this. And the last comment that I had is that, today, a lot of us are looking at it in terms of the existing legal provisions as misinformation or fraud associated with short selling. But, it could be that the relevant agency here may not have any shares at all or may not have transacted. It could be that, you just pay somebody without any personal gain, but to destabilize a company, to destabilize the economy, to destabilize a nation. So I think we also have to be alive to that, the factor may be that the disinformation or the person circulating the information may not classically fit as a short seller, because they may not be trading in those shares. But the damage is in any case done. And what we are concerned with is all dimensions of the damage, not just the short selling.
Thank you. Thank you for beautifully deconstructing this issue for the viewers. Also explaining to us the kind of perils that we are exposed to with this kind of an ecosystem and why it needs to be corrected. As usual, a pleasure talking to you, Mr. Shah, and looking forward to see you again on some other topic. Thank you. So now we are joined by Mr. Mahesh Agarwal. He is managing partner of Agarwal Law Associates, one of India's leading law firms at the Supreme Court of India. Good to see you, Mr. Agarwal.
Good morning.
And thank you for joining us. I want to ask you this today, that does India need a better securities regulation framework to prevent against misleading reports, which could lead to losses to millions of middle-class shareholders if such reports come out? A little bit of your analysis and your opinion on this issue.
So I would say this, that we already have a very strong and robust regulator in SEBI. SEBI has been performing this function since the year 1992. And the whole purpose of SEBI's existence is investor protection. The pillars to our stock market are investors. Everything centers around investors. The basis on which SEBI is currently functioning is disclosure system. It's the disclosure based protection to investors. So what is ensured is that all key information, sensitive information is passed on to the investors in terms of various stakeholders making reports. The company whose stocks are listed, it's supposed to give full disclosure of all relevant material. Anything that happens has to be informed to the investors on real-time basis. And SEBI makes sure that investor protection is paramount based on disclosure system. That's the whole system on which it works. Now, currently what is happening is that some report is published 10,000 kilometers away from the country, and that has an impact in the Indian economy or in the Indian market. What happens is that today, unfortunately, the investment is not just based on the real strength of the company, but also on investor sentiment. Now,
Yes.
the sentiment is most important. You have 10 people selling stocks, 100 will follow. In Hindi, it's called bhed chal. That's what is happening. Now, the bhed chal is starting because of some report published outside India. What can SEBI do about it? Unfortunately, SEBI today has no control over any such report being published outside India and which has a direct impact on the Indian economy or the Indian stock market. Another important thing is that there are two independent aspects which happen. One is somebody publishes a report. That's fine. Second is that the same person makes an announcement that I will short sell. He is manipulating the market. So there are two aspects of the same person. One is a report which purportedly says that I am doing this for investor protection, but actually it's not for investor protection. It is for self-benefit at the cost of causing loss to millions of others. So a short sell happens, market manipulation happens on the basis of the report. This is nothing but a complete corporate espionage. Now that has to be protected by SEBI. I'm not on the question of the report is right or wrong. What is currently happening is even before somebody examines that the report has some credibility, the report is right, the loss is caused, damage is caused, and the person who's conducted the corporate espionage has made a profit of thousands of crores at the cost of Indian investors. This needs to be checked in some way.
Thanks. Thank you for sharing that. And would you also link that this is a criminal act sometimes? Because if it is done, if I take the right figures and give a wrong interpretation to those figures and put out a report, do you think there is an element of criminality there, or it can't be said?
So criminality would be surely with regard to market manipulation. Insofar as report is concerned, somebody may publish a report. That report needs to be investigated, needs to be examined. Investigation has to happen. That's a separate issue. But what I'm on is market manipulation. It is not simply a report issued in public interest. For example, say a reputed Indian daily, say Times of India, Indian Express, Economic Times. Their job is journalism. Their job is to give information. Their job is to give articles. That's fine. But they cannot indulge in manipulation in the market. And that doesn't happen. Here, it's a combination of both. Not just a report, but immediate manipulation in the market is nothing but criminal.
So, Mr. Agarwal, if you could share with us any suggestions that you would like to give on such an issue.
So I would say that if SEBI has no control on an international agency publishing reports and manipulating in the market, then it should do what it can do in India. What can be done on real-time, immediate basis is suspend trading of a stock on which manipulation is happening. If there is a chance of loss to Indian investors in thousands of crores, then till there can be some credible search with regard to the report, the market should be suspended straight away for 3 days, 5 days, 7 days. So investors are protected. Otherwise, what happens is that a report is published, the market sentiment is hurt, and there is a bhed chal of selling shares or short selling shares, and people are losing money. Now, SEBI has a mechanism of redressal, but this is something which cannot be redressed. If somebody has lost money in the market, how do you redress it? So there has to be a check straight away of suspending in the market. Then after that, what SEBI can do is call for an interim report, call for responses from the company, from the institutional investors, all the stakeholders, come out with some study and publish in the market for disclosure. There has to be disclosure from SEBI, because there cannot be any disclosure from a foreign agency who's done this mischief. So SEBI has to step in a robust way to ensure that there is no money lost. Point one. Point two, that in current times, when everything depends on social media, on WhatsApp messages, and on reports shared on WhatsApp, what has to happen is that SEBI must be a part of some international network of investor protection agencies, so that information is shared, and SEBI has the power to take action outside India. Currently, SEBI has no power to do anything. In a situation like this, where something had happened in India, SEBI would have booked the person, put him behind bars straight away. Now here, it's happening outside India. So SEBI has to undertake itself, have some agreements, some MOUs, some consultation papers, and align with foreign agencies to take action.
Thank you. Which you also, what you said also means that somebody with a criminal intent from any country can use these tactics to short shares, and that is what we need to be wary about.
Absolutely right.
Now we come to the moot question, and the question is: does India need a better securities regulation framework to protect against misleading reports, which might cause loss to thousands of people and also damage the economy of a country? In many cases, it can also have irreversible financial implications. I'll go over to Advocate Abhimanyu Bhandari, who understands these things, has done work in this area on the legal side. Thank you for joining us, Abhimanyu. And what do you think on this?
So, Tarun, my view is that for any healthy economy, for a $5 trillion economy that we are aiming to be, the edifice of any strong economy are two things. One, a strong capital markets and a strong banking industry. Now, we need to bring in a legal framework which allows quick disposal of disputes relating to banking disputes or to capital markets. I think the topic today concerns the equity capital markets. Now, a lot I'm reading in the press where people are saying short selling should not be allowed, but that's completely wrong. Short selling is also lifeblood of a healthy and a good capital market. A person should be able to do a long sell, should be able to sell short. And that's important. And therefore, there's nothing wrong in it principally. What is wrong is that any person, whoever wants to create panic or havoc in the market and comes out with misleading information, which other people clamp on and then start selling or start, let's say, selling shares and cause that the share price of the company to go rock bottom, or the other way around, where misleading information may come and people may then start aggressively, individual investors, retail investors may start aggressively on the basis of that information, start buying shares, and that information may be wrong. Now the question arises, do we have a legal framework which ensures that this kind of a situation can be addressed? Now, Tarun, the problem is this. We have a good legal framework when it comes to a company making a wrong disclosure. So, for example, take a company which comes out with a prospectus which is completely misleading. So we have section 35 of the Companies Act. We have various things within the SEBI legal framework where you can prosecute the company. You can you can file a case against the company and its directors for coming out with a misleading information in the prospectus of a company when a person is trying to allure that person to either buy a share of the company or to deal in securities of the company. But where we are lacking, Tarun, is the legal framework where individual investors can sue not the company, but let's say any third party who comes up with misleading information about the company. So, for example, let's say X publishes a report in the media and conducts a propaganda where he says, everybody, look, this company is doing really well. We've done research on this company, and according to us, this company is getting this particular contract, and this company's shares will double, triple, and people start then subscribing to that, not knowing that that information is completely untrue. And that has a material impact on the share price of the company. And people then buy the shares of the company, and then eventually the shares collapse because that information on the basis of which people bought was untrue. The question is, as an individual investor, what remedies do I have? Yes, SEBI can take action against the company and its directors if they're involved. But what a situation arises where a third party comes up with some information about a company, where directors and promoters of the company are not involved. What rights do I as an investor or any investor have against him? That is where we are falling short. We don't have. Now, for example, the common law is that in tort, I can go and sue a research analyst if he comes up with a report which is wrong. I can sue him in tort for a duty of care. Probably it will take years. Even my grandchildren won't see the decree by the time the suit completes and I complete the trial. So where do I go in such a situation? Well, as an investor, I need some protection so that I can directly sue any third-party analyst or any third-party firm which comes up with a report which is misleading. Now, under the US Securities Exchange Act, 10b-5 allows that. And there is a culture where investors often sue not only the company for any misleading information, but if the company has not given any misleading information, but a third party comes, a brokerage comes, or some kind of a firm comes which disseminates wrong information about the company creating and individual investors suffer, then individual investors can sue that particular firm under 10b-5, where if you make an untrue statement, you rely on it, and that causes havoc. Now, we have trappings of that in the new Companies Act of 2013. If I'm not mistaken, it's section 35 or 36. But that again takes you to penal provisions where it says those people who've created that havoc probably can be prosecuted. I am not on that. I am on a quick remedy where a person can get sue for damages if he has suffered damages because of a third party action or a third party misleading report on a company. So we need a proper framework on that. We also need to ensure that such cases are not filed in a normal court of law like a civil suit, which can go on for years and years. But there should be a quick disposal of such cases, either with the SEBI tribunal or with the NCLT, if those provisions are in the Companies Act. But we need more of a summary trial kind of a tribunal where one can go and one can seek damages if there is a misleading report that comes up. So therefore, Tarun, it is extremely important that while we may have a system where SEBI can take action against a company for insider trading, its promoters and directors for insider trading, or for publishing some wrong information in the prospectus, or under the Companies Act, an investor can take action against a company for doing something wrong in the prospectus. There is very little where an investor can directly take action against a third party who's created a havoc. And that's the legal framework we need. Remember, in the US, there is a huge culture of securities litigation. Investors, individual investors, retail investors, professional investors are many times suing brokerages, analysts, if they come up with a wrong piece of information which causes them to enter into a transaction which is wrong. So that's the culture that we are missing. And that's the kind of legal framework that we need to bring in, where individual investors have a quick disposal, summary trial that they can go for against any misleading report that one comes across against.
Thank you for sharing the view from the American markets as well, for us to understand what we must evolve and develop. I'm sure the Parliament would consider and soon pass a law, because I think it's a need of the hour. And with what happened in India in the recent times, everybody, in a sense, is aware of this problem. So that was Advocate Abhimanyu Bhandari joining us on this issue. We move on to our next guest. Thank you so much, Abhimanyu, for sparing your time. Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.